Hello, part 3. Here we go. Um, so that's Amendment 4. That's pretty much what we're gonna cover. So if you look back and my little pocket constitution that I love, just as a review for Amendment 4. In all criminal prosecutions, the accused shall enjoy the right to a speedy. Oops, no, that's that's Amendment 5. Sorry, meaning to review Amendment 4 for you guys. Or that was Amendment 6. I'm way off. Like, obviously, I don't have my handy pocket constitution turned to the right page. Okay, Amendment 4. This will sound more familiar to you. And really, I'm just reading it again. So get your Constitution books out, your Bill of Rights, and read along with me, because I really want this to all sink in for you very clearly. Amendment 4, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. It's a good one. It's an important one. But, obviously, now we do number 5. And number 5, it's a big one. It's a really big one. Look at that. Look how big that is. Yes, it's a big one. It's chocked full. It's got a lot of stuff in it. There's a lot of stuff that we're going to have to go through with Amendment 5. And it's stuff that you guys are familiar with. It's words like due process. It's things like, grand juries, and what does that all mean? The concept of double jeopardy is a part of Amendment 5, so dig in. Let's dig in. Okay, so to begin, let's read Amendment 5, okay? So read along with me while I read. No person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury, except in cases arising in the land or naval forces, or in the militia when in actual service time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. Nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Okay, so as I was reading through it, I was thinking about all the things that are embodied within this amendment, all the protections, all the issues that arise, and I suspect that you guys were thinking the same thing. Now, when people think of I'm sure, right? That's what you were thinking, like, wow, all the things. Yeah, I'm sure you were. Okay. The thing that people think of when they think of the Fifth Amendment is what? Like, I plead the Fifth. Has anybody ever heard that? I plead the Fifth. Very famous people have pled the Fifth, and sometimes people even just sort of jokingly plead the Fifth. And that really only refers to one tiny, well, not so tiny, it's important, but one small little line in the Fifth Amendment. The Fifth Amendment is much, much more than just that component. It actually contains maybe one of the most important protections. And I hate, how do you even like to say what is the most important protection? But, due process being such a critical protection that you guys have. So, and that we all have. But not only that, the right to a jury and a grand jury, the right to have a public, well, no, not a public trial, but the right to not be pursued essentially by the government in sort of punishment prosecutions, and lots of other things. So let's get started. We'll talk about it here. All right. So the first part is no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. So that first, like in my book, it's like 2.5 lines, essentially says that no person shall be held to answer for a capital crime, a crime against the state, or otherwise infamous crime. So a crime that is deemed to be bad, a bad crime. Now, the idea of what an infamous crime is and something that is a capital offense, those are important pieces here. Because what that essentially establishes immediately is that the Fifth Amendment applies to serious cases, that these rules apply to people who are being charged with things that are pretty serious. What it immediately eliminates is like small claims, what we think of as small claims court. In the American judicial system, we have courts that are divided up into different sort of levels of court. For many of you, the only interaction you will ever have with the court systems, on a personal level anyway, will be either with a small claims court. Maybe you had to sue your landlord for back rent or something like that, and so you take that to a small claims court, or a traffic court. You got pulled over for running a red light and you're confident you didn't, so you go before traffic court. And those are not considered capital or infamous crimes. And therefore, this initial provision, this provision of the grand jury, which we're going to talk about in a second, doesn't apply in those cases. And the courts have generally held that sort of small misdemeanor cases, cases that are considered less serious crimes, you don't have the same right to a grand jury as is outlined here in the Fifth Amendment. Now, what that doesn't mean, it does not mean that the rest of the rights of the Fifth Amendment don't apply to you. You still have the right not to be a witness against yourself. You still have the right not to be deprived of due process, even in a traffic court situation, even in a small claims court situation. It really only attaches to the right of presentment of indictment of grand jury. So that's an important piece. So I want to just say that one more time to make sure it's clear. I'm going to explain in a second what an indictment is, what a grand jury is, but this initial piece, this idea of, whether it's a capital crime or whether it's an infamous crime as compared to a misdemeanor or a smaller crime, it is only relevant as far as the issue of an indictment or grand jury is concerned. In all the other rights of the Fifth Amendment, regardless of whether or not you're suing someone for $500 or you've been pulled over for a traffic stop, you have the rest of these rights. And when I explain to you what a grand jury is and what an indictment is, I think that will make more sense to you. Unless, of course, I'm repeating myself and you're all going, yeah, get on with it, we get what you're saying. It's so strange, I don't really know what you're all thinking out there. So, okay, we'll keep going. You'll have to tell me on Wednesday whether this all made sense. Okay, so grand jury. So no person shall be held to answer for a capital otherwise infamous crime unless on presentment or indictment of a grand jury. Well, first of all, we talked earlier in the first part of the semester about juries and jury systems, and that juries were actually established by manor courts were the initial kinds of juries where you would have they would have investigators that would investigate the crime, and then they would determine who. It was sort of like the detectives at the police department being the detectives and the judges, and they would pronounce sentence. So that's how it was in initial manorial law. But now we separate out the job of the investigator from the job of the decider. And but what Madison establishes with the notion of a grand jury is that before anyone can actually be brought to court, before the trial process can begin, before a prosecution can actually fully get underway, what Madison established through the Fifth Amendment, in this very first clause of the Fifth Amendment, is that the government has a duty to demonstrate that there is essentially a reason or cause for this case. The prosecution itself must be essentially confirmed or justified through what's called the grand jury process. Now, in the state of Wisconsin, we do not call it a grand jury. In the state of Wisconsin, we call it another name. We call it actually a preliminary hearing. But the preliminary hearing and the grand jury are essentially the same notion. They do the same thing. A grand jury is a jury that does not find guilt or innocence. Rather, what a grand jury does is a grand jury determines whether or not there is probable cause to believe that a crime has been committed and that the person being prosecuted or the prosecution that is being sought against the right person. It is essentially intended to be like a firewall that protects individuals from prosecutions that are unfair. So if you think about it like this, the grand jury acts as a barrier between overzealous prosecutors, people who are, think the cops think they have the right guy, the prosecutors think they have the right guy. Well, through through an investigative process, sometimes people can be convinced of things that aren't really true. I mean, think about what happened in the Brenton Butler case. Those cops very likely believed that Brenton Butler did it. They likely believed that Brenton Butler was the one who killed that woman, even though the evidence was, in hindsight, after watching the film and seeing all the things that happened, it seems kind of ridiculous to think that this kid committed this crime with almost no evidence. Well, what the grand jury is supposed to do is they're supposed to be sort of an unbiased third party. The party that essentially stands outside of the investigation. And, police officers and prosecutors, they have a lot riding on investigations actually being successfully prosecuted. If you put, 6 weeks of your life and your professional expertise into hunting down a suspect and you think you've got the guy, well, it's going to be really hard for you to pull back or to resist analyzing that case and rethinking, going, well, maybe this isn't the right guy. And so the grand jury is supposed to kind of say, does this seem reasonable? It's one of those ways that, the balance, we talk about this, I'm talking about it again. I want you to think about, in your head, think about those scales. When you are arrested and when you are put on trial, what Madison and the framers essentially saw was that this system, this enormous system, is extremely, extremely outweighs you. It's a really, really powerful system. So what you really need is you need systems and practices that are going to be put in place that are going to try to bring it back into some kind of, equilibrium. And what the grand jury is intended to do is to bring that back, to give the accused some kind of an opportunity to say, this is unreasonable, there's nothing that's reasonable about this. And so what the grand jury does is they just look to see if there is cause. Is there cause to believe that A, there was a crime committed, and B, that the person who committed it could be the person who's being charged. But grand juries are often called prosecutors' juries because they actually are, in Wisconsin, they're called preliminary hearings. So the prosecutor's preliminary hearing, because it's not a real trial. While there are jury members, there are people, and in the state of Wisconsin, it's frequently just a judge who makes the determination. But you have, a panel of people who represent the grand jury, just like they would represent on any other jury. But they don't hear defense witnesses. They only hear prosecution witnesses. And the reason for that is because it's the prosecutor who's trying to convince them that there was a crime and that it's likely that this is the person who did it, or that it's reasonable to believe that this person could have done it. So when a case comes before the grand jury, the defendant isn't putting up a defense. All a grand jury does is presents, in the Constitution, presents an indictment. If at the conclusion of the prosecution presenting its witnesses and making its arguments, if the jury believes that, this is reasonable, then they can present an indictment. And an indictment is simply a formal charge saying this person is indicted, this proceeding is going to go ahead. However, while the defense does not have the right to present any witnesses at that time, they can ask questions of the prosecution's witnesses. And I'm going to stop here and go on to part 4. And in part 4, I'm going to tell you about a preliminary hearing that I witnessed see work. And I'll tell you that story in just a second. So end of part 3, and please go to part 4.